Thank you so much, everybody, for attending our local Public Safety Coordinating Council meeting for April. We're going to go around the room and do introductions. Did want to let folks know, I think we put a note in, but please raise your hand if you would like for us to unmute you, and we'll do that during the introductions. So my name's Kiki Parker-Rose. I'm the Community Justice Director, and I chair the PSCC.
Josh Aldrich, Captain with the Sheriff's Office and Vice Chair of the PSCC.
Danny Jordan, County Administrator.
Basic Sheriff. Randy Sparacino, County Commissioner.
Justin Ivins, Police Chief, and I apologize, I might have to sneak out here early, so I'm not being rude if I leave. Sorry.
Travis Christian, Direct Construction Citizen Member.
Clint Oborn, Public Defender.
Alyssa Clausman with the District Attorney's Office.
Andrew Hickson, Director of the Children's Advocacy Center, Jackson County.
Lucy Durst with the District Attorney's Office. Cindy LaBelle, Jackson County Deflection Coordinator.
Bobby Devine, Community Justice.
John Hamilton, Community Justice.
Want to just do it one by one?
Sure. Online, Dr. Carter, can you introduce yourself, please?
Sure. Dave Carter, Southern Oregon University Citizen Member.
And Jennifer?
Jennifer Maloney, Executive Director of CASA Jackson and Gisborne Counties.
And Nathan Olson.
Nathan Olson, licensed clinical social worker, citizen member.
And Rita?
Rita Sullivan, psychologist and community member.
Perfect. And then Mariah Long?
I'm a social work student, Mariah Long, citizen member.
Thank you. And Sarah Roberts?
Yeah, Sarah Roberts, I'm with Central Point City Council.
And Mayor Graham.
Tanya Graham, Mayor Mashon.
That would be everybody.
Okay, great. Thank you, everyone. First order of business, we sent the minutes out. I would entertain a motion to approve our meeting minutes from 2026 March.
Move approval of the minutes.
Second.
Okay, a motion second. All those in favor of approving signify by saying aye, and those online can raise your hand.
Aye.
Okay. Anyone oppose or abstain? Perfect. All right. We have the privilege today of having a presentation by the child abuse prosecutor as well as the Children's Advocacy Center. And so really, this is a part of the system that we don't talk a lot about, and that's victim services and victim rights and the process of what folks go through throughout our system and then after they leave the system. So I want to welcome both Lucy and Tammy, and the floor is yours. And I'm not sure if we told you, but we like you to stand right there. Okay, perfect.
There we go. All right, thank you all for having me. Like they said, I'm Lucy Durst. I'm one of the Senior Deputy District Attorneys at the District Attorney's Office. I have been a prosecutor, I guess with my internship time, close to 15 years now. I did the child abuse caseload in Benton County, Washington State, as well as in Jackson County. So for today's presentation, what I'm going to walk through is what I've just titled From Report to Trial. So from the point that our office is receiving a report that involves or alleges child abuse and through trial or ultimate resolution. Why this topic? So April is National Child Abuse Prevention Month. And the goal of that nationwide is to bring awareness and show importance, the importance specifically of communities working together to prevent child maltreatment. I have some stats on here, it's kind of small, I apologize, of child abuse in the United States as a whole that was obtained from the National Criminal Justice Training Center. There are 4.3 million children referred to CPS, which is Child Protective Services in the United States. 28% of those become screened-in reports. There are just over 500,000 victims of abuse and neglect nationally, and an estimated 1,700 children died from abuse and neglect in this calendar reporting year of 2024. I do want to state that when you see CPS, Child Protective Services, in the state of Oregon, that's the Department of Human Services. So if I'm saying DHS today, that's interchangeable with CPS and what I'm referring to. In the state of Oregon, the Oregon Child Abuse Hotline, which we call ORCA because we love our acronyms, is where calls and cross-reported police reports go in. For the fiscal year of 2024, within Oregon alone, there were 169,623 reports of child abuse. Of those, close to 95,000 screening reports were documented. Close to 46,000 were assigned for assignment to a DHS worker. Of those, 38,000 an assignment was completed. And then once an assignment is completed with the Department of Human Services worker, they either find or not find it. And they had 8,424 cases that they determined were founded for abuse, which is approximately 8% of the screening reports that came in. And those 8,000 founded involved 11,669 victims. Of those victims, we're dealing with a really vulnerable population. Not only are they children, but close to 36% of them are 5 years and younger. So as I go through the presentation and back to the purpose of Child Abuse Prevention Month is to bring awareness to the community partners. Those are our teachers, our hospitals, our CAC staff, as you'll hear from Tammi. With kids this young, with 40% under the age of 5, we're often dealing with children who are just becoming verbal, just practicing and being able to have a narrative statement about what happened. One interesting thing, if you look at the stats from Oregon that highlights just how important the community partners are in preventing child abuse, during the years of COVID, the reported child abuse cases in the state of Oregon dropped drastically. That's because children weren't in schools, they weren't seeing people who were mandatory reporters of what was happening. 21% of cases are reported from school, with another 30% being from various mandated reporters. So today, as I go through my presentation, what I want to do is outline how child abuse cases are prosecuted in our office from report to trial, explain the role of the district attorney's office specifically, which includes describing charging and case building decisions that we're making as we evaluate and prosecute a case. And again, highlighting the coordination with investigative partners and our MDT, which is our multidisciplinary team. So what is child abuse? People have various definitions of that. I'm going to go through kind of what my caseload is assigned. So I'm assigned cases involving both physical and sexual abuse of children under the age of 18. Physical abuse can be assault, criminal mistreatment, or strangulation, and the names of these are derived from the Oregon revised statutes that we would charge. There's various levels of assault. I'm not going to go through the whole ORS for you, but just know that they are dependent both on the severity of injury and that there are certain levels that are specific. For example, in assault 1 can be a child under the age of 6, assault 3, child under the age of 10. We also have child neglect statutes, which include child neglect 1 and 2. This can involve a child being in or around where drug manufacturing is. It can also be if you leave in an area or such a place for long enough that they might be endangered. I put criminal mistreatment up here twice. One of them is if you have legal duty to care for another and cause physical injury. But then it also falls under kind of our neglect, where if you leave a child attended in a place for such a period of time, that may be likely to endanger the health or welfare of a minor. We have the sexual abuse cases that we have, rape, sodomy, unlawful sexual penetration, and sexual abuse. And then what I call our computer crimes. That first one, online sexual corruption of a child, is where you're using online messaging to engage in sexual contact or explicit conduct. Encouraging child sex abuse is what you would think of as your child sex abuse material, or CSAM, or child pornography cases. And then luring is a computer crime where you use a computer or a phone, and you furnish either to a minor or an undercover officer posing as a minor a description of sexual conduct for the purpose of engaging the child to meet with you. So that's an overview of the cases that my caseload involves. So the role of the district attorney's office specifically, we review reports, police reports, as well as DHS reports. The DHS reports come to us through a police officer who has started that investigation. We work with law enforcement and child protection agencies. And one of the ways that we do that, working with all the partners as far as the beginning of a case, is through what's called Carley's Law. So in the state of Oregon in 2008, Carley's Law was enacted after a 3-year-old in Corvallis died following abuse allegations that went unchecked. So following that, the state of Oregon codified and mandated that any suspicious physical injury in a child, so anyone under the age of 18, needs to be addressed in a coordinated effort amongst agency partners. I always like to point out suspicious physical injuries refer to injuries that are suspicious for child abuse, not just injuries that we don't know how they happened. And some of the legal requirements for that are that they receive medical attention within 48 hours. So they'll be seen urgent care, emergency room, or by our designated medical professional employed at the Children's Advocacy Center, that photos are taken, and that if the designated medical professional employed by the CAC doesn't personally see that child, they are reviewing the photographs and the documentation and the medical records, because their training and experience is specific to this is suspicious for inflicted injury. They are trained to look for things. You know, this was a report of a hanger. Yes, that bruise has markings that look like a hanger, or the reported mechanism that caregiver is providing car accident doesn't match what we're seeing, so we need to investigate more. We make charging decisions by applying the facts of a case to the specific charges under our ORS. If it's a felony case, we're presenting the cases to the grand jury. Another important part of our office is with victims' rights. I didn't bring one for everyone, but there's a victims' rights guide in the state of Oregon. And so victims in Oregon have specific rights in their case, in conjunction with a right that a charged offender might have. So they have specifically after an arrest to be notified of certain court proceedings, any release hearing. A big one is being consulted about a plea in a violent felony case. So on all of my cases, most of my cases that are violent felonies, that's not something I can look at and just make the offer. I'm coordinating with our office to discuss with that victim, primarily through their caregiver, whether the child themselves is involved or not, about what an offer might look like. And then they have rights in court as well, such as speaking at sentencing, or preventing photography and audio in certain cases from being released. And then also in our role at the DA's office, like I said, it's taking the report and then if it's charged, moving forward to a case resolution, whether by negotiated agreement or a trial. This is just an outline of our office's, hierarchy. And one thing I like to point out that isn't necessarily unique to our office, but that our office does, is we try as best we can to do what's called vertical prosecution. So when I receive a case in my intake, I'm reviewing that case for charging decision. I'm then handling any motions in that case. I'm handling the negotiation in the case, and ultimately I would handle the trial. For example, some bigger counties, I think King County in Seattle and maybe Multnomah County in Portland, they have an intake unit. So someone is charging all the cases and then different people get it later on. So we try as best we can to do that. And then our victim services, we have victim assistance program director, and she oversees various Victim witness assistants, I have Paula. She's wonderful. She's assigned to my caseload. She helps coordinate, inform the victims of specific court hearings, get their input. A lot of what she does is reaching out and saying, hey, we're about to make an offer. Do you want to be a part of this? Does your child want to be a part of this? We also have a few victim witness assistants specific to domestic violence, and there are kiddos involved as witnesses to that as well. So our initial report and review, again, our office at the point that we're receiving it is receiving reports directly from law enforcement who has received them from DHS, other mandatory reporters, family members, or community members. And then they are conducting the investigation to include interviews or evidence collection. That's oftentimes in conjunction with our conversation about what types of things we should pursue. And then just on the right here, I just really want to highlight that all of these things really have to, all of these entities and people, SROs, family friends, DHS, really work together. And when those parties all work together, that is when we are really able to make a difference preventing child abuse. When making a specific charging decision, these are various factors that our office and myself review when looking, we call it intake. Is there probable cause that the crime occurred, which is a substantial objective basis for belief that more likely than not an offense has been committed and a person has committed it? Does the charge adequately describe the offense committed and the charges provide for an adequate sentence? The statutes have very specific elements that I have to meet. I'm sure you guys are all aware. It's not a layman's terminology for it. So I have to make sure each specific element is met. And then these are just additional factors to consider, such as the nature of the offense or the probability of conviction, interests of victim, any mitigating evidence. One thing about my caseload specifically, when we receive what we call intake, it's a unique caseload. We get a lot of referrals that aren't ultimately charged out. So going back to talking about Carly's Law, any injury suspicious for child abuse is being referred to law enforcement. They're investigating, and then I'm getting that report. Some of those reports might be involving parental discipline. And in the state of Oregon, we do not recommend physical discipline, but there is a carve out that if it's a reasonable use of force, it's not criminally charged. So some of those come in. A lot of the cases are pre-verbal children who have really profound abuse. I had a case a while ago, and I know we met with the CASA on it, and this child was, I think 18 months old, severely physically abused, could not handle touch anymore, is going to need therapy for the rest of their lives. Neither parent confessed to it. No one witnessed it. So that's something where I get a referral for both parents, and I know one of them did it, but I need to be able to show which one caused which specific injury. And that can be really hard and frustrating when reviewing. Oregon is unique in that we don't have a torture statute. I think there's maybe 14 states left in the US that have not codified a crime along the lines of child torture. And just generally that's defined as like repetitive physical abuse, extreme mental anguish, starvation, and some states require you to have 2 or 3 out of that list. But in states that have that statute, it does open up a little bit more ability to charge things. If you have a child where both parents have, for example, equal custody, or you can prove both parents are in and out of the house and the child is very malnourished, I can attribute that to both under a torture theory, whereas right now, if I have to do caused physical injury, I would have to prove which individual parent specifically didn't feed a child on a specific day.
And can I ask a question? In the case you just exampled, did one of the parents report the injuries, or did someone else report the injuries of the child?
They're usually coming in from someone else. So the case I was talking about where I wasn't able to charge, parents had taken the child to the pediatrician for, I think, a bruise on the leg. And then they went in, pediatrician did an x-ray. The femur was broken, sent to the ER for a full evaluation, and then they do a full skeletal scan. And the parents were reporting, I think this bruise is from a bee sting. And that doesn't match the mechanism of injury. They were parents who were living in like a hotel motel. There weren't outside people that saw the child. There weren't neighbors that ever saw them with the child. So there were two parents. We know that the father primarily worked out, but he would be seen coming home, 7 p.m. to 6 a.m. in the morning. Mom was there during the day. We couldn't attribute the child's cries or screams to any specific time frame to try and narrow it down. And there were multiple fractures.
So the serious physical injuries weren't obvious. There was just a bruise that you could see that was obvious.
Yes.
The reason why I'm asking is child neglect or endangering the welfare of a minor seem like appropriate charges if they were obvious.
Sure. Yeah. So child neglect is, I did write down specifically. So it's worded really specifically. So child neglect 1 is a child under the age of 16 and you leave in an area where controlled substances are manufactured or within a premise that's been determined not fit for use by a government entity. And child neglect 2 is leaving a child in a place so long that they might be endangered. So a hot car or something. They aren't, if I could show that someone knew about the injury and that the child had been crying, so even if I don't have a confession from, say, the father, and he says the kid's been crying, I saw them losing weight, all of these things happening, I saw bruises, then I might be able to, under criminal mistreatment, charge that in violation of a legal duty to care, didn't take the child in for necessary medical care. Our statutes and case law defining necessary medical care leave a lot to be desired. It's medical care in which death is certain if you don't receive it. So a broken bone doesn't always get me there. But yeah, they're really tough statutes to fit within that.
And endangering the welfare of a minor also.
Endangering the welfare of a minor is usually referring to the controlled substances as well, like in a car where a controlled substance is.
Or driving offenses.
Yeah. Like a reckless drive or if there's children in the car. Okay, so factors unique to child abuse cases compared to other cases. I'm primarily relying on a child's statement to prove my case. Of course, sometimes I have physical evidence like a DNA kit or a sexual assault kit. Sometimes there's a witness, but oftentimes there's one witness to the abuse and it's the offender. The reason for that is the offender is the one choosing to inflict the abuse. They are the person solely in control of when and where this happens and who might be witness to it. Lack of physical evidence, developmental ability of a child to testify, the timing of a disclosure. So this primarily is a factor in my sex abuse cases. Who did the child first talk to, under what circumstances, and why did they decide to speak out now? I'd say the majority of my cases are not an instance of sexual assault of a child that happened and they report it immediately where physical evidence can happen. It's, maybe a 6-year-old saying, well, we moved in next to my aunt and uncle and my aunt and uncle have a 6-year-old and I don't want what happened to me to happen to them. So you're asking a maybe, 10-year-old to talk about something that happened when they were 6, relay that back in a specific statement, not saying this is how it always happened, but this is how it specifically happened in this one time. Victims' fear of negative consequences. Sometimes victims recant. Sometimes what we see is a child will say, well, I tried to tell my mom and kiss me and my mom kind of brushed it off. And so the child doesn't go on to disclose more because in their mind, from their perspective, they attempted to reach out and disclose, got shut down, didn't think they were believed, and then they don't report further. The case building and pretrial process. So we have ongoing case building. By the time I get the reports for investigation, detectives have done their work or officers. But then as we get defense investigation or different statements from other witnesses, there can be follow-up or different experts hired to help. Another part of our pretrial process, again, is the victim advocacy. We want to support the child and the non-offending caregiver, explain the court process, notify them of critical stages. And one really, I guess I would say, balancing act or thing to consider in these cases is it's the state of Oregon versus the offender. I am the one making the charging decision. I'm the one making any specific offer. But we do have victims that are required to testify if these cases go to trial. So you're asking a victim to go to court in a room with their offender and tell in front of 12 strangers what happened to them. So it's balancing, a victim's ability to do that, a willingness to do that. It isn't a complete deferral to a victim, but every case is different. Every kid has different developmental abilities to relay what occurred to them. Every child has a different support structure when they go home. If you have, a non-offending parent crying the whole time, saying you broke up the family, that's a lot harder for that child to go to court. We have pretrial court dates and motions. In the state of Oregon, we can file what's called a child hearsay notice, which allows, as you'll hear from Tammi, most of our young children are interviewed at the Children Advocacy Center in a forensic interview, which is a safe, open-ended place for them to talk about their bodies and what happened to them. And in the state of Oregon, I am allowed to use that video so long as the child is also at court available for testimony. Prior bad acts evidence is a motion that I frequently file. Criminally, you can't say because someone did something before, they're going to do it again. But specific to sexual abuse cases, the state of Oregon with case law has held that sexual propensity for minors, you can talk about other past acts, but that needs to have a judge ruling on it. 412 motions are, usually I'm arguing against them, but a defense attorney might file a 412 motion and it's regarding victims' past sexual behavior or propensity. And so I'm saying your sexual behavior prior does not mean that you're a victim in this case. We also have just standard motions to suppress, motion to suppress statements of the offender, and defense motions involving records. Let's see. Case resolution. We resolve our cases via plea negotiations. Sometimes we have a settlement conference where a judge helps us. I always like to point out that in plea negotiations, as I hinted on, no two cases are alike, and it's really trying to find that balance of holding this offender accountable to the extent allowed by the law to protect society from this person, but also finding that sense of justice with the victim themselves. My victims in my cases, they don't get to choose that they were victimized. I always let them know I'm going to use my training and experience, my past history, that their only job is to be honest about the case, and in return, I'll be honest about any strengths or weaknesses. I don't want to take that choice away from them. It's not up to them to resolve the case, but it's also one of the few pieces of this entire process that I like to give them autonomy with, because they didn't choose any of this, and there's nothing I can do. 100 years in prison, which I can't actually legally do, but there's literally nothing I can do that takes it away. So we really like to make them feel heard, and usually, but not always, through conversations about strengths and weaknesses or what this might look like or not look like. By the time we're at the end, they feel heard and satisfied, but it just does lead to different resolutions because each case and each child and each set of facts is different. Trial, if we don't have a negotiation. For sentencing, we use the Oregon sentencing guidelines. Sometimes a pre-sentence investigation is conducted by the probation department. And then following any sentence, they're on either probation or post-prison supervision. And then just other responsibilities as a DDA in my caseload, we put on trainings with law enforcement and community partners. We go to case call-outs. We have after-hours advice, search warrant review. I'm chair and head the fatality review, which investigates deaths for any child under the age of 18 in Jackson County, criminal or not criminal. And then we are a part of the multidisciplinary team, which Tammi is on with me as well with the CAC. And then just enclosed by the numbers, and I put the caveat up there that these numbers were done by me. I did not ask our office manager, and she's probably a lot better at pulling my stats of numbers. But in 1 year, I had 251 cases referred, 134 cases charged, 306 cases were disposed, so it could have been cases from the previous year that then resolved. And I had about 6 trials. I'm not really good at my trial stats. But yeah, the cases referred, like I said, DHS is very often getting reports, sending them to law enforcement. Oftentimes law enforcement is sending them to us, not necessarily thinking they're able to prove it or could prove it, but sending in for review. Or, for example, the child fatality cases, if it's a sudden unexplained infant death, that's sent to me as part of my review, but those aren't criminal in nature, so that accounts for some of those numbers. Any questions?
I think at the end of the day, this one's just for my own. I was raised both with abuse and then was part of it. I had a sister who I had her kids, but at the end of the day, is the goal always to get them back with the parents? It's something that I always struggled with. Like I struggled with it in my own personal case. My parents had all the rights until you're 18. You just had no rights whatsoever, and then. Fast forward 30 years, I had a sister who ultimately died of drug abuse, but the only involvement I would ever get is when the kids would test positive for drugs at some appointment, and the state would call me and say, please come get the kids. And I'd say, wait a second, why are we giving them back? Like, what is the process seems to always go back, and it just has been, I don't know. This is such a thing for me, but I just don't understand the always go back to the parents.
Sure, yeah, that's a great question. I will try and give my best at an answer. DHS would probably have a better answer. I know that a lot of cases are focused on reunification with the parent, and there's been a trend kind of in that general direction. I don't have the studies on me, I apologize, but there's been studies like the trauma of a child being with their abuser or bad situation versus being taken from that situation and placed in resource care. And I can speak from what I see about it. And, I see kiddos tell me all the time, like, I don't want dad in trouble. And it's something that they're not processing the safety that could come from being away from them. And so just psychologically for that child in that moment, I know there's been a definite trend in that direction that I've heard from people and have seen. We also, some of my really more serious cases, it's handled by DOJ in coordination with DHS, but I have had a few cases where parents have either agreed to or gone to a termination of parental rights hearing. But yeah, it's I think there are expert psychologists and experts that could answer that better than me, because I know on the outside it doesn't always seem to make sense.
It just seems, it took my sister dying to get the kids in a right spot, and I think, how in the world is that good for the kid? I just never have understood it, and it would always be pitched to me that, I'd say, well, I'll adopt the kids. Well, she has these rights. It's rights. Like, what point do you lose your rights? I never have understood it.
And that's a separate process. I mean, that's a separate process than Lucy has to deal with usually. Yeah. So that's like
my extent is I usually have a no contact order while my case is pending or while on post prison or probation. But yeah, that's with the Department of Human Services and Department of Justice that handles kind of that separate process. If we can go back to my honeybee picture, we all work together but have very unique little roles that we fill in.
And that's the 419B statutes, which are like, the criminal statutes are usually like the 130s, 160s, all that. This is 419B, which is like the juvenile dependency statute. So it's dependency versus criminal. And so like you're talking about like 419B 500 is a termination of parental rights. 419B 100 is like a dependency case. So those can get conflated because sometimes people will be, like lots of people will be involved with DHS, but they're not involved criminally necessarily based off whatever the circumstances might be. And so there's a crossover for sure, but not always.
Lucy, we have a question from Mayor Graham.
Yes. So Thank you for your presentation. I have a question about the child torture law that Oregon doesn't have on the books. That seems like a strange element to be missing. Is there anything that, as we think about that, is there a reason why that has not made it through? Has no one put it forward, or can you just speak a little bit? Because I can't for the life of me conceive why we wouldn't have that law in the books.
Yeah, unfortunately, I'm not familiar with the legislative history of why we don't. I know that in, I think my at least 10 plus years here, I don't know, Alyssa, if you remember differently, I don't remember anything being proposed on that. But I am happy to look into that and follow up with you if that would be okay, because it is a definite gap. A lot of our conversations that we've had at MDT have surrounded, I guess, why we don't have it. And of course, it's frustrating when I go to nationwide trainings and, their presenter from Texas talks about all these things that, they could charge. But yeah, I'd be happy to follow up on that and get back to you with some kind of history behind that.
That would be great. Thank you. I have a follow-up if that's okay.
Sure.
Okay. So as an elected leader, we go through a lot of various trainings when we first come in to service. And one day I was at a League of Oregon Cities conference, and the speaker said, how many of you here know that you are mandatory reporters? And 2 hands maybe in a room of 50 went up, because nobody actually trains us. So is there a process where maybe at the state level where we look at all of the people who are identified as mandatory reporters and make sure that they have access to some kind of training? When I heard that, I just went and found something online, but it just seems like there's a big disconnect there for elected people and maybe for other categories of mandatory reporters. So just wondering if you have any information about that.
Yeah, I am not sure what the governing would be for elected people's mandatory reporting. I know for all attorneys and I'm required to do continuing legal education that requires me to submit, I think it's 3 mandatory elder and child abuse reporting credits every 2 years. I know there's something similar for teachers in order to keep their accreditation, as well as medical professionals. I'm not aware of a statewide governing one. Our office has also put on trainings both internally and externally regarding mandatory reporting. So that's something, that I could offer, but I don't know if there's an overall governing board that's making sure that's happening for that population. But I will add that to my list to get back to you on.
Thank you.
All right. Thank you.
Thank you.
Really nice presentation. Thank you. Tammy, you're up.
I'm Tammi Pitzen. I'm going to try to stay behind the podium. That's not my norm. I'm the Executive Director of the Children's Advocacy Center of Jackson County and have been there for 12, 13 years now. So the Children's Advocacy Center of Jackson County facilitates a holistic, multidisciplinary, trauma-informed response to child abuse. We work very closely with Lucy and Lucy's office and law enforcement and child protection. We don't do investigations. We're not able to do investigations. We gather information for those who are doing the investigations. So the Children's Advocacy Center of Jackson County is our name. The Children's Advocacy Center is a model. And the first picture there shows what it was like before the movement came around. Kids would be interviewed 15, 20 times about their experiences. They would go to different places. The professionals that were working with those on those cases were not talking to each other. I started my child protection career in a very rural part of Louisiana, and this was my reality. We did not really work together. Our local law enforcement would take my DHS report and send it straight to Lucy or her counterpart at the DA's office with very little intervention done. But with the Advocacy Center, and particularly here in Jackson County, we are able to provide these services in one location. So they can come, they can get a forensic interview, they can meet with the professionals. So instead of the professionals going the child going to a lot of different places, the professionals come to one location and are able to conduct their investigation. So before there was fragmented systems, different agencies worked separately, children had to tell their story multiple times, and it added trauma and confusion. So the vision of change came around in 1985. A district attorney named Bud Kramer in Alabama, in Huntsville, Alabama, had just had a very successful trial and was talking to the child that was at the heart of that trial. And I think he thought he was going to get accolades because they had won the case. And the child said, I would never report again. I would never go through this process again. It was horrible. And that kind of opened his eyes to look more at this process of what happens to children when investigations are made for child abuse. And so his goal was to create a coordinated, child-friendly approach, and created out of his insight the systems that need to collaborate so children won't be re-traumatized by the very process meant to protect them. So it revolutionized the response to child abuse. Today we have over 1,000 advocacy centers in existence across the country and some out of the country. We have a coordinated, compassionate care for child victims. CACs transform how communities protect, investigate, and care for children affected by abuse. So locally in 1987, some of you were around when Mark Huddleston decided to gather a group of professionals and lay people, and they created the Jackson County Child Abuse Task Force, which is now the Children's Advocacy Center of Jackson County. We began providing services in 1991, and in 1994, we were part of the first class of accredited children's advocacy centers across the country. Year to date, we have served more than 17,000 children that are local children in our community with therapy, forensic interviews, medicals, advocacy. So the multidisciplinary team approach, a child tells their story in a safe space using a process that minimizes trauma, minimizes contamination of the information, and maximizes the information gathered. That's the forensic interview. That's what the forensic interview does. This line used to say that they tell their story one time. What we found is that sometimes it takes a child more than once to tell their story, particularly if the abuse spans over a very long time, or if they have more than one offender. The team shares information with each other and coordinates care, and this team includes law enforcement, CPS or DHS, prosecutors, medical providers, mental health experts, advocates, forensic interviewers. In our county, we have CASA is also part of our multidisciplinary team as well. We're accredited by the National Children's Alliance, and really what that means is we have standards of care that we have to adhere to, and they cover these topics of the multidisciplinary team: forensic interviews, victim support and advocacy, medical, mental health, case review and coordination, case tracking, organizational capacity, and child safety and protection. Basically everything from what kind of insurance we need to carry and how much of it, all the way through how we and who conducts forensic interviews, who's providing advocacy and what kinds of training, and the same for medical and mental health. So the CAC provides these services in a trauma-informed manner and in child-friendly environments. We provide access to therapy, advocacy, and medical care around their abuse. We don't provide primary care. Our medical providers, we have 2 part-time medical providers, and when we're fully staffed, we have, I think, 7 or 8 pediatric sexual assault nurse examiners that work for the CAC, but do their work at the hospital when kids present acutely to the hospital, which is very rare. We provide a sense of safety and validation, and the CAC's focus is on rebuilding trust and emotional stability for young survivors. Our job between the time that they tell their story and Lucy may charge is to help that child feel engaged in the process and to feel safe to be engaged in the process. So our focus is building communities where children are safe and families are strong. That used to be a little bit longer than that, but we decided our mission statement was so long that we would cut what we were actually trying to do down a little bit. That mission statement is to meet the needs of children and families in our community by providing a community-based, child-focused center that facilitates a compassionate, multidisciplinary approach to the prevention, treatment, identification, investigation, and prosecution of child abuse. I have been there for 12 years. I have to read that every time because I can't quite get it to come off my tongue. We serve children 0 to 18 who've experienced abuse or witnessed violent crimes. All of our referrals come from DHS or law enforcement. We cannot have, we do have moms or dads that call and say, I suspect my child has been abused. I want you to interview them. I want you to do a medical exam, but I don't want to report it to law enforcement. Believe it or not, in the state of Oregon, advocates are not mandatory reporters. The Children's Advocacy Center has a policy that our advocates, our staff, our volunteers, and our board function as mandatory reporters. But actually in the state of Oregon, believe it or not, advocates are not child abuse mandatory reporters. I started down that road to tell you that we couldn't have a mom come and want forensic evidence created without our law enforcement partners, our DHS, there to collect it. So the interventions that we use at the CAC are evidence-based. They're nationally defined as best practices. They're trauma-informed. We provide some services that are bilingual, and those that aren't, we provide interpreters. Children are referred to our forensic services through law enforcement or DHS. Our therapy services, some children can access those without going through law enforcement or DHS if that has been reported as they are a child making a disclosure of abuse. It has been reported and either declined to be investigated or it has been investigated in another place. So they move here from California and they need services. If we have the capacity, we accept those. So we provide forensic interviews, medical evaluation, treatment, and diagnosis for child abuse. Our 2 medical providers are the designated medical professionals for Jackson County. Every county has to have a designated medical professional. They do either Carly's Law evaluations, so they actually do the evaluations, or if they are unable to do the evaluations or the parents choose to go to the emergency department, their primary care provider or urgent care, then they do an extensive records review, which is basically every medical record that they can get that they know exists for a child from birth to the current situation. We do therapy. Oh, let's see, that one went really fast. We do therapy assessments, groups, individual therapy, family therapy. We provide family support and advocacy. We provide prevention trainings and outreach. And so our advocates are assigned when kids come in for a forensic interview, and they provide support services. They help with community referrals. Most of the time when kids come into the Children's Advocacy Center, our biggest concern is whether or not they've been abused. And if they have been abused, how to secure safety. For many of the families, that comes down as a lower priority, not because they don't care about their child, but because they don't have food in their refrigerator. They're not sure where they're going to sleep. They have mental health issues. They are in the middle of a divorce. They're victims of domestic violence. There's a lot of things going on in their life. And our advocates are there to remove as many barriers as possible. If they will engage in group, we bribe them with gift cards to purchase groceries or to pay, we call it gas reimbursement. The same thing if they will engage with their child in therapy at the Advocacy Center. So is there a need in Jackson County for a Children's Advocacy Center? We serve around 600 to 650 individual youth every year. We in 2025, we provided over 9,000 individual services to these youth. Last year when I came and spoke to you guys, we provided more than 5,000. So in the last year, we've almost doubled the number of individual services that we're providing. Jackson County's rate of child abuse is higher than the national average, the average per 1,000 children. Oregon's higher than the national average as a state as well. So why does child abuse matter locally? Child abuse impacts children and families across Jackson County. Rural and regional dynamics increase vulnerability. Local systems face capacity and access challenges, and every case affects the broader community. I have a theory: if we invest heavily in our interventions to child abuse, and we do it consistently for about 20 years, you will see a decrease in our mental health crisis. You will see a decrease in the homelessness, and you will see a decrease in substance abuse. Kaiser has a study out called ACEs. I'm pretty sure everybody has heard of ACEs, Adverse Childhood Experiences, but it links things like homelessness, things like health disorders like obesity, high blood pressure, some cancers, diabetes, back to childhood trauma that's not been resolved. Substance abuse definitely, and a lot of mental health issues. So hundreds of children in Jackson County are referred annually for concerns of abuse. Cases include physical abuse, sexual abuse, neglect, and exposure to violence. Many cases involve multiple forms of trauma. I just did our quarterly, I'm in the middle of, I call it Grant Palooza because it's all the grant reports, but just pulled our quarterly numbers. We served 200 kids January through March. And some of them were first time, some of them have been with us for therapy. Of those kids, there was 257 allegations of child maltreatment made. So many of those kids, 19 of those kids had multiple forms of abuse. And I don't have the exact number, but more than 5 have been through our doors multiple times already for other abuses and other cases. So the common risk factors in Jackson County that kind of feed into our abuse rate is substance abuse and addiction, domestic violence, housing instability and economic stress, and caregiver mental health challenges. And the impact abuse has on children, trauma impacts behavior and emotional regulation, physical and mental health, long-term life outcomes, and without interventions, impacts can extend well into adulthood, both with physical health, emotional health, and social. So why investment matters. Early intervention reduces long-term health costs. So if we, I was shocked when I looked at the study and things like diabetes were on there. So I always think of diabetes as being something like high blood pressure. Sometimes you can control that. Diabetes, I always think that's just how your body is processing insulin, right? So, but a lot of health, chronic health problems are the result of unresolved trauma. And so we can save money in our health costs, in our emergency room capacities, and in our urgent care capacities. Criminal justice involvement, intergenerational trauma, and investments strengthen families and community safety. So we know if we can break the cycle of abuse, if you grow up in abuse and you haven't found safety and you haven't resolved trauma, you haven't taken steps to do that, we find that those adults somehow find themselves in this pattern or cycle of abuse. And we see it a lot in sexual abuse, is what I will say, with moms in particular. I'm sure dads too, but dads don't open up to me as much as moms do. And when I was doing direct services, almost about 50% of the parents that came into the Children's Advocacy Center had experienced abuse themselves. And they would be vigilant for their kids and thought they were doing the things that they needed to do to keep them safe. But they were repeating patterns of what they felt was normal. And so sometimes found themselves in abusive relationships, which led to their children being hurt. So what's new? What new kind of community interventions are on the horizons for the CAC? We are launching a new prevention program as part of our Protect Our Children. So the person that asked about mandatory reporting, we have someone who can do mandatory reporting training as well. We have a online safety training that we're launching out it has curriculum for kindergarten through 12th grade, and there's also an adult component. So we started launching that out, and we have our greatest success is when we can embed facilitators in other agencies. And so we have, right now we have, for the new training called Safety Net, we have facilitators with Medford School, the school resource office. 2 of the school resource officers have been trained, CASA, Community Works, and then the CAC. And we also have a new sexual abuse prevention training called Connect to Protect that will be launching as soon as we've received the facilitation training. And that will be added to Stewards of Children, which we already currently facilitate in the community. We have a new strategic plan, newly adopted, so we will start working on our new strategic plan. Part of that plan is to expand supports for non-offending caregivers, because we know that if we can find a safe adult that can be supportive and can be taught tools to keep their children safe, kids do much better in that environment. And so we want to expand, and that is also part of our prevention efforts. An expansion of our campus. This has been the ongoing saga. We bought a building behind that's adjacent to our campus, behind our intake center. We've gotten as far as demoing it, and we have this nice flat lot, and we will begin to make plans for the expansion of our CAC. And that is it. Yes.
So during the height of Measure 110, if my memory serves me correctly, we were provided some cool stats on the exposure of children to drugs since Measure 110 has been modified. Have you seen a reduction in the exposure, or is it still high?
I don't know how to answer that question, and I should have looked to see what the statistics are, so I will get those for you. We're still doing it's a hair strand testing. We're doing it when it's medically indicated. You might know how often. We're not as often as what we were doing before, but it might be just how the way that we're getting the cases now versus how we were getting them before. But I need to look at that. For a while there, I do think most of the kids that we test come back positive, but we're not testing everybody that comes into the CAC. So every child that comes into the CAC is not getting tested. So that's that could be an inflammatory statistic that I throw out there, that they're all coming back, but it's a subset of the population that we're seeing. I think it's gotten somewhat better. I think we could probably do a little better for the kids. They're just, and we don't test kids who can go to they can drive themselves to a party, and part of it is that there's drug exposure. We're not probably going to test those kids for that. Yeah.
You said Jackson County has a high rate of child abuse in Oregon as well. Do you know why that is, or have any ideas? Or have you done any studies or research compared to other states and counties to see where and why we have this issue?
I like to think it's because we're a little more. So I've done this work in 3 different states, in Louisiana, in Colorado, and here. I can, and I can't speak for the state of Oregon, but I think in Jackson County we're looking for it, if that makes any sense. So if you have systems in place that are going to look for kids that are unsafe, you are likely going to find them. And so I can use our ICAC and SOSET, the 2 teams that look at online stuff. It's like fishing in a bucket, right? Like every time they put the line out, they're going to catch somebody, and that is going to go into our statistics, right? So it will increase. We do have. It costs a lot of money to live in Oregon, and I think that financial stressors impact parents. I think substance abuse, when you are abusing substances, it is hard to be a good parent. It is hard to be engaged. So I think those things are there. We have gaps in our system to address mental health. And I think adults who have mental health that have kids, it's hard to stay focused on your parent or your children and your children's safety when you're in survival mode yourself with your mental health. So I think all of those things play into that. You could probably look at some of the interventions that we use and compare them to other places. If you went that deep, there will be places that intervene earlier. Our system is very reactive. One things that we have that is sort of that is allowed to disrupt, I think, as far as allegations of abuse. So DHS is very reactive, as well as law enforcement. One of the things that we have that other states don't have is a category or an allegation called threat of harm. So you can find for threat of harm. So they've not been hurt yet, but they're at a threat of harm to be hurt, and there's a lot of things can fall in that category. And that's I think, innovative and a great way to disrupt. It doesn't mean you're going to go remove those kids because they're at threat of harm, but it is something. It is an extra step there that you can disrupt what's happening earlier.
Just what? So you said, we have a higher rate than normal. Can you quantify that? And then two, what qualifies? Because you said child abuse, but yes, we have this, but then said threat of harm is considered a definition of child abuse. So what qualify? I guess I'm getting at the Sheriff Sickler asked about, what's causing that. But I think in order to understand what's causing that, what are we qualifying as that, and what are these quantifiable numbers that are saying we're high? What are these percentages or numbers generally, or something that way?
Yeah, I don't have the. Are you pointing at me or asking me to talk?
Both. I was going to look it up on my phone because there's a website that has all of that on there.
Yeah, I was going to say the National Criminal Justice Training Center had a lot of statistics. I haven't looked up other states, so I'm not familiar with them. But when she's referring to threat of harm, that's a finding specific to the Department of Human Services that they can make. And so our Department of Human Services would report instances of child abuse, not necessarily criminal. And in Oregon, that's going to include threat of harm, sex abuse, neglect, substance use, domestic violence, or mental injury. So I haven't looked at other states, but I know that Oregon is unique, as Tammi said, with threat of harm. And so that could expand what's being qualified or counted as child abuse. And also, like she said, we have our SOCIT and ICAC teams are high-tech cases. We have really proactive teams that get a lot of those cases. The CAC was one of the first accredited in the country, so we've had a really solid community that is invested and, like she said, looking for that since 1987. So that's ahead of some other communities. Mayor Graham?
Yes, thank you. So I wanted to go back to the prevention question. You shared a lot of information that I think we generally see in our communities, where the long-term impact of child abuse just shows up in so many ways. And so getting out ahead of it, getting upstream of it, I think is a really important process. And we also saw the risk factors that you shared. Is there any effort to connect the prevention trainings to people who are experiencing those risk factors who have not yet entered into the advocacy center because their child has been harmed, but maybe somebody who's coming forward who needs housing assistance, or someone else who is receiving mental health treatment? Are those connections being made? Because it seems that those are the folks who are at the highest risk of being the people who might get overwhelmed, who might have these moments where appropriate training might be able to help them navigate those moments without it turning into child abuse.
Yes, but more can be done. So we provide all of our trainings free. We provide them to youth serving organizations. We provide them to the community at large. We have given them to as few as 2 people. If they show up, we will do the classes. We have them scheduled. We have one of the things that I'll say is that in some regards, some of the population we have to be cognizant of how to provide that information. We have tried sometimes to go to that high-risk population. They're receiving services somewhere, so we'll go to that place to do training. But again, the high likelihood of that population having been abused themselves, that the training in and of itself can trigger them. And we need to make sure, so we try to make sure that one of our therapists is around, or that we have someone that is there to take care of those things, because the last thing we want to do is to trigger them and then leave them. The classes are a couple of hours. Let's spend a couple of hours talking about all these things that are going to trigger you, and then we're going to leave you in that state. Feels not good. So we try to plan those out a little better, but they're open classes. My internet is not I can follow up.
I appreciate it.
No, that's good. Thank you.
I didn't mean to cut you off, Clint, so is that okay? She's going to follow up with you.
That's perfect. That's great.
Okay, great. Anyone else have any questions? Well, great. Thank you, you guys. Excellent presentation. It's really informative. Tough stuff, definitely. And I really hope that, you are doing a bunch for Jackson County and our community, and I hope you find ways to take care of yourselves as you take care of the community, because it's hard stuff. So thank you for that. All right. That concludes our meeting. We are adjourned. Thank you.
Thank you.